Lawyers are no musicians or ballet dancers. A lawyer's training, skill, and ethics are still essentially rooted in national legal system, and it's far from clear how and to what extent national professional rules apply abroad to the transnational lawyer in the international arbitration process. Well, I don't think you needed this quote from Vivi Vidir to learn that lawyers are much less elegant and eloquent than ballet dancers or musicians. But I think it highlights well the one of the key questions that this paper seeks to address, whether national professional rules governing the ethical conducts of lawyers apply to their practice before international tribunals. And I submit that there's also the converse question that is equally important. So whether international ethical obligation apply to nationally regulated lawyers. So my name is Jonathan Brosseau. I'm a PhD candidate at McGill and Paris 1, Panthéon-Sorbonne. And my answer to both questions is yes. Yes, but a qualified yes, because, and this is, I give away my thoughts on this in the title of the paper, which is a jurisdictional framework for resolving ethical issues related to party representation in international arbitration. And the key is in the subtitle, distinguishing the procedural from the deontological. So we'll get back to this point throughout the paper. But first, I just want to highlight why I think this paper could be of interest for comparativists. Well, first of all, the paper compares national laws to find the best solution to different ethical issues, and also it seeks to harmonize international law over critical issues. And I mentioned that the scope of the paper is international arbitration, but I submit as well that there's a keen interest to the determining today whether some of the same issues apply to international law, public international law, so representation before other international courts and tribunal. And here I note that just over the summer, Judge Adok Kress, in his declaration in the Gambia versus Myanmar, noted that the ICJ should reflect on how it should deal with difficult factual and legal difficulties in identifying the government of a given state for a purpose of representation in proceedings before the court. So the brief outline of my paper, there's 4 parts. First, I'll look over the problems with the ethical representation, with the ethical governance of lawyers before arbitral tribunal. Second, I'll explain why the arbitral should deal with the procedural. Third, why the national should deal with the deontological. And fourth, I'll explain how to bridge the gap between the national and the international or the arbitral. So first, the problem with the ethical regulation of arbitration lawyers. So you would know that arbitration lawyers are subject to the ethical rules of various jurisdictions. So that could be the jurisdiction where they're licensed, or jurisdictions where they're licensed, the foreign jurisdiction where they practice, or the foreign jurisdictions where they practice, the jurisdiction, quote unquote, of the arbitral tribunal, and even in certain instances, the jurisdiction of the national bar of the arbitral seat. Well, this fuels 2 different problems. The first problem is the double deontology problem. So this is when an attorney is bound by the rules of, a set of rules that compel him or her to engage in a conduct that is strictly prohibited by the other sets of rules. And here, take the comparativist joke that the United States and England are 2 countries separated by a common law and a common language. When we apply this to ethical obligations of lawyers, we see that both countries have very similar rules, but still, even those 2 countries have different approaches to similar ethical issues. And then, for instance, one issue is whether a direct communication with an adverse party that the lawyer knows is represented by lawyers is possible or not. So the second problem is the inequality of arms problem. And here, the question is whether the fairness and integrity of the arbitral proceeding risk being compromised by one side having an advantage over the other because of varying national professional rules. What type of answers have been found to these issues? 2 different ones, one at the national level and another at the international level. At the national levels, this is typical of countries where federal countries, so or for instance, the European Union. So when there's the issue of how to deal with the representation and the ethical rules of lawyers appearing before different national courts. And the problem is that these rules, so we have the IBA rules, there's also the CCB Code of Conduct, the Code of Conduct for European lawyers, that have conflict of law rules to decide the ethical obligations of which jurisdiction apply to lawyers. But they take typically a territorial approach, which means that they focus on the rules of a national jurisdiction and the application before the national courts, and don't take into consideration the representation before international courts and tribunal. The second set of measures that is taken is international law soft law rules, typically. So here we have the IBA guidelines on ethical representation and all sets of other rules, but these instruments typically apply only if they do, in addition to national professional rules, and they do not specify how they interact and practice with these rules. So they typically fail also to prescribe beyond abstract terms what conduct is expected of representative in arbitral proceedings. These approach, the national and the international, also assume that ethical obligations are monolithic, though that they exist in a single block, and consequently they adopt a binary logic. Either national or international regulators should prevail altogether. Well, the approach that I take, which is based on research from David Wilkins at Harvard, is based on a different framework, and it assumes that ethical obligations are multifold, and based on this revised framework, I identified three. Procedural ethical obligations, so typically what type of conduct is expected before the court. Deontological, which means really focus on protecting the integrity of the profession as a whole. And then liability, so these are either civil law, so when your clients, for instance, can sue a lawyer for malpractice, or criminal, when a lawyer can be prosecuted for criminal behavior. So as I've introduced in the introduction, now I'll explain in part 2 and 3 why the arbitral should deal with the procedural and why the national should deal with the deontological. And the main point, so I move on to the second part, why the arbitral should deal with the procedural and the procedural only. And here I'll focus on why on the parts of the paper which I believe are the most innovative and consequential. And the argument is as follows. The New York and Exceed Convention authorize, limit, and mandate a limited form of ethical regulation in international arbitration by enforcing procedural ethical obligation. And I'll distill these 3 points. First, the convention recognized that parties can consent to the resolution of the representative's procedural ethical obligation, since these obligations fall within the scope of submission to the tribunal. So basically what the tribunal can enforce. Second, the New York and Exceed Convention circumscribe party autonomy through their notion of arbitrability and investment dispute. So what the tribunal cannot enforce. And third, the ground to challenge arbitral award in the New York and Exceed Convention mandate the parties' equality of harm in the arbitral proceedings. So what the tribunal must enforce. And I submit that these 3 points on ethics are equally applicable to the ethical regulations of arbitrators, funders, and experts, but I don't have much time to get into that. And I'll come back to what is the consequence of this of these 3 points in the last part of the presentation. Moving on to part 3, why national should deal with the deontological and the deontological only. Question, what's the difference between a good arbitration lawyer and a great arbitration lawyer? Well, the good arbitration lawyer knows the law, and the great arbitration lawyer knows the arbitrator knows comparative law, obviously. What does comparative law tells us about the deontological? Well, first, that the arbitral tribunal is an inappropriate forum to deal with deontological issues. Why? Because when we do a survey of nearly all jurisdictions under national law, we see that the proper administration of justice requires that deontological and liability obligation be decided not by the adjudicator of the dispute, but by specialized tribunals and jurisdiction. So the same should, and this is based on consideration for the administration of justice. The same should apply to the international level. So it wouldn't make sense and be coherent with fair trial principles that the arbitrator dealing with the substance of the dispute would be the same deal to deal with complex deontological and liability obligation. And it's also quite clear that bringing the tribunals into the disciplinary process burdens the parties, delays the proceeding, becomes a weapon in the arsenal of dispute resolution tactic. But conversely, the procedural ethical obligation of national professional rules. So the rules that govern the ethical obligations of lawyer before the court should disapply to international arbitration proceedings, and actually a true choice of forum and choice of law rules. And actually they have in certain instances, and I'll explain that. So for instance, in certain jurisdictions, like France, the national bars have included arbitration exception to specify that the rules, certain rules of courts don't apply to international arbitration, specifically to address the inequality of arm problem. And here, in the case of the Paris bar, there's an exception now because Paris bar members cannot typically prepare witnesses before trial, and it's an accepted practice in international arbitration that the council can prepare witnesses, and the Paris bar has made an exception to specify that Paris bar member can prepare witnesses before arbitral tribunal only to address the inequality of arm problem, and mentioning that this is actually a positive step for France and Paris and the Paris bar. And I come to my fourth and final point, and it's bridging the gap between the international and the national. So here I have 2 points. The first really quick one is that arbitration rules should make express the power of arbitrator to enforce a lawyer's procedural ethical obligation. So I've mentioned that the New York and Exit Convention allow this. The problem is that they are vague, and that's their goal. And my point is that they should be supplemented and specified in these powers should be specified in arbitration rules. So stating expressly the power of arbitrator to enforce lawyers' procedural ethical obligation. And the reason why is because right now arbitrators rely on their inherent powers, and they must have some discretion in controlling the proceeding before them, but not having explicit or express rules can make them wary of overstepping their powers. So I think that arbitration rules should include these provisions, and this is the case, for instance, of the LCIA rules. But there are LCIA rules only. And unfortunately, last year, ICSID, in its revision process of its arbitration rule, decided not to make an amendment to make this power express, although I did make the very compelling point in the comments that they requested in one round of the comment that they should. My second and most important point is I believe that national regulators and courts are typically unaware of potential breaches of the ontological and liability obligation occurring in arbitral proceedings, notably because these proceedings are typically confidential. And I suggest that one way to address this gap would be for tribunals to have the express power in arbitral rules to report serious misconduct related to those obligations to national regulators where party representatives are licensed. Couple different points. I say serious misconduct, not in all instances. One other counter argument is that this proposal, against this proposal, is that arbitrators are bound by confidentiality obligation under national arbitration law. But I explained, and I reviewed in the paper, and I explained that the mandatory rules of national arbitration laws in many jurisdictions actually include exceptions to confidentiality obligation, such as for those I suggest. One obvious exception is that the parties can consent to disclosure, and one type of consent would be if the arbitration rules to which arbitrators are signatories, or at least that are incorporated in the arbitration, provides for the power of tribunal to report serious breaches, potentially serious misconduct to national regulator. But even without this exception, there are others that apply. For instance, arbitrators are relieved of their confidentiality obligation and able to make disclosure in the interest of justice. Disclosure can also be required either by law or by a competent regulatory body. So I suggest that this proposal, and this is my final point, would strengthen tribunals' power to control representatives' conduct and represent a positive step in the self-regulation of international arbitration. With that, I think I've exceeded my time, and I thank you very much for your kind attention.